Hi all, how you doing? Welcome. We this to another webinar in an ongoing series to bring digital insights to various businesses. Last time we presented cybersecurity with our good friends at Vistrata. Today we're going to co-host with Therese Arendt, partner at Morit, Hawk and Hamroth, to present the business of ADA website compliance. Hey, Teresa, how you doing?
Hey, Jeff.
Uh, Good. Well, thank everybody for coming. I have just a few details that I want to get through, a little housekeeping, and then we're on our way. While people are starting to siphon in, I just want to give you like an overview, right? So in today's digital age, sustaining an accessibility website or an accessible website is not only a practice, it's the law. The Americans with Disabilities Act requires, or the ADA requires businesses and organizations to make their digital content accessible to individuals with disabilities, creating an inclusive and barrier-free online experience. In this webinar, we'll explore the key principles of ADA website compliance, the legal implications of noncompliance, and some of the steps you can take to remediate your website to meet these standards. So whether you're a business owner, lawyer, web developer, digital marketer, or other, this webinar will provide you with valuable insights on ADA website compliance. So let's forward the slide. So just a legal disclaimer, I'm not going to read the whole thing, but the first sentence has this presentation and the information provided herein are for informational purposes only and do not constitute legal, financial, or professional advice. And so the rest of the legal disclaimer, if you wish to read it, it's there, but we have to put that out. So next slide, please. So let's get in some introductions from both of us. So both Therese and I are going to be co-hosting. So Therese, can you give us a background on who you are and who you represent?
Sure, absolutely. First of all, good afternoon, everyone. Thank you so much for joining us today. And a huge thank you to Jeff and Connect 360 for inviting me to participate in today's webinar. My name is Therese Arendt, and I am a partner in the law firm of Morit, Hawk and Hamroth, where I chair the firm's marketing, advertising, and promotions practice, in addition to co-chairing its privacy, cybersecurity, and technology practice. We are a full-service corporate commercial law firm with offices in both New York as well as Florida, with a diverse practice and experience in virtually all areas of law that affect businesses and their owners. Thank you, Jeff.
All right. Next slide, please. And I am, once again, Jeff Smith. I'm CEO of Connect 360. I've been running this business now for over 5 years and have a sort of a lifetime in the world of marketing, both on the B2B and B2B side. So we are a full service marketing firm specializing in digital, traditional, and business communications with one clear focus, delivering ROI. As you can see here, at Connect 360, we are dedicated to developing data-driven strategies that fuel growth, boost engagement, and enhance brand visibility. We work in both B2B and B2C sectors with a strong presence in industries such as fashion, finance, food, pharma, and everything manufacturing. So please go online. We're going to throw our contact information in the chat as soon as we have a second. And check us out. Go online to our websites and connect with us. So just as a last bit of administrative understanding before we get going, please know that all the attendees will get a recorded understanding of the entire presentation, the actual presentation, and ways to connect with us following. So we'll just have to wait on Zoom in order to get that recorded understanding. We'll throw it up on a website and off you guys go. You'll get that. We welcome your questions and comments, so you can post it in the Q&A or the chat. And we'd love to field those questions, hopefully during the presentation if we can, or at the end. So that's where we are. The last piece of things we're going to be doing besides presenting is we're going to be having 3 polls today. of which we're going to start, I believe, the first one. So let's launch into that. These polls are, oh, I'm sorry, slide before that, but that's okay. We can launch the poll. Let's do it. Go ahead, launch the poll. Go for it. That's okay. I'll cover the agenda while the poll launches. So again, it's just real quick. So we're going to go through ADA web compliance. We'll check out the legal process, and we'll understand some digital pathways to compliance, both on a reactive and a proactive understanding. So this is a little bit of a knowledge check, and I really like to see if we can get like everyone to make and cast their choice here. So I'm going to read through it real quick. So how would you rate your current knowledge and practice of ADA compliance? Okay. So it's two parts, right? So it's, your rating on your knowledge and the actual practice of compliance. So A would be, I'm very knowledgeable and my website is compliant. B, I'm somewhat familiar, but my website needs some improvements, right? C, I've heard about ADA compliance, but I'm unsure where to start. And D, I'm unfamiliar with ADA website compliance and haven't implemented any practices yet. So please cast your votes and say and submit. So what we're going to do is that as we're waiting for that real quick, we're just going to make sure that, we're going to aggregate, it's already available. So let's get the results. So we get results, please. And the results are C. I've heard of compliance, but I'm not sure where to start. Therese, what type of reflection do you have on that?
Well, I think that our attendees are in the right spot.
Fantastic,
But
fantastic.
because certainly today what we're going to cover is, a little bit more of a hopefully information that will give them a better understanding of what ADA compliance is and exactly where to start.
Awesome, awesome. With that said, let's get on with the presentation. So I believe it's Therese leading us off.
All righty, sounds good. Thank you, Jeff.
You're
So,
welcome.
of course, the most important place to start with all of this is what exactly is the ADA? Well, as relevant to this webinar, Title III of the American with Disabilities Act is a federal civil rights law that was enacted in 1990 to prohibit discrimination based on disability in places of public accommodation. A place of public accommodation is generally defined as a business or organization that is privately owned but provides goods and services to the public. As it was enacted, the ADA provides standards that are required for the physical location of a business to accommodate a disabled individual. So, as most of us are familiar with the ADA, what does that mean? Well, you're familiar with a store having to have, wheelchair ramps, accessibility to those that are handicapped bathrooms, can't just have a staircase, is an escalator enough? Do you need an elevator? Yada, yada, yada. Everything that applies to a physical location. So now, of course, the problem was that at the time that the ADA was enacted, the internet as we know it today did not exist. In fact, the World Wide Web was not introduced until 1993, 3 years after the enactment of the ADA. And this is important because what does the ADA not do? It does not expressly limit its coverage to brick and mortar locations, but it only makes reference to physical locations. It does not expressly exclude online locations, and nor does it provide any guidance whatsoever for digital accessibility on either websites or mobile sites. So, of course, this has created an ambiguity that is subject to interpretation of the law, since the law didn't keep up with either the times or with technology. Next slide, please. Since the ADA doesn't address online locations, then it likewise doesn't provide any guidance for whether it's applicable to websites. And if it is applicable, what standard should be applied to create compliance? So, of course, what happened after 1990? We have no internet. And over the next decade, what happens? The internet absolutely explodes. And in 2017, the first ADA website accessibility case went to trial in Florida. In that case, a blind man sued over 70 companies, including Winn-Dixie, the grocery store in Florida, alleging inaccessibility of their website and that it had denied him the full and equal enjoyment of the goods and services that were offered by Winn-Dixie to their cited customers. Now, this case was significant because it was a landmark decision, as it was the first time that a judge held that a business's website was in fact subject to the ADA, and the court ordered the business to update its website to comply. It was also the first court ruling that ordered compliance with a particular standard. And that standard was, at the time, was the WCAG 2.0 guidelines, which are the Web Content Accessibility Guidelines that you'll be hearing a lot about later in the presentation, which were established by the Worldwide Consortium, sometimes referred to as W3C, which is an industry group that was created to develop standards and guidelines for the internet and its long-term growth. So I will note that the case was ultimately overturned in 2021. It had an absolutely tortured litigation history that we're not going to get into for purposes of today's discussion, just in the interest of time. But the short of it is that the 11th Circuit ultimately overturned the district court decision. And then later they vacated their own decision on technical and procedural grounds, which basically left the state of the law in Florida in a pretty murky state. But nonetheless, it's a very significant landmark decision because it was the first lawsuit holding that, yeah, the ADA does apply to a website, or certainly can. And it absolutely fueled the onset and the surge of lawsuits, because now you had at least one court holding that the ADA applied to a website. And coupled with that, you had the Department of Justice was consistently taking the position that the ADA does apply to web content. Now, the DOJ, they're the agency responsible for implementing rules and guidance under the ADA. But here's the rub. They don't have any regulations that actually regard accessibility as relevant to online places of public accommodation. And this lack of clear standards has led to a wide split of authority in the courts. First, does the ADA even apply to websites? There's been some split in court decisions on that issue. I will tell you, though, that it's, most courts do hold now that the ADA does in fact apply. And if there are some courts out there that don't, it's definitely trending in that direction. But the bigger issue that gets litigated is whether or not having a standalone website alone is sufficient, or are you required to have a nexus to a physical location? So just by way of example, in California, the courts have held that you do need a nexus with a brick and mortar location. Here in New York, however, the courts had consistently held that no nexus is required, but rather that simply having a standalone website is more than adequate. That is until last week, because it's a perfect demonstration of how these laws are just constantly changing, and the courts are continually changing their interpretation. Just the other day, we were surprised when the Southern District came down with a decision that held you do need a nexus with a physical location. But in the meantime, other courts in the Southern District had held you don't. The Eastern District still holds that just a website alone is sufficient. So now, at least with regard to New York, not only do we have conflict with the laws in other states, but now we have conflict within our very own state, depending on where you're sued, whether you're in the Southern District or whether you're in the Eastern District. So good times. Next slide, please. So just wanted to run through some statistics here to show just how prevalent these suits are and why this is such a very important topic. You'll see just from 2018 to 2023 alone, more than 20,000 lawsuits were filed based on ADA website noncompliance. It's been predicted that for 2024, we're trending towards at least 4,000 suits being filed. Ranges between federal and state court, although most of the cases I'm seeing are in federal court. I can tell you that I just received some updated statistics just this morning that indicated that in September alone, 342 lawsuits were filed just in September. And out of those lawsuits, 101 of those defendants were repeat defendants. They had been sued more than once.
Wow.
So this is important. Now there has been a teeny tiny little slight downward trend over the last year in some of the jurisdictions, because, the good news is that courts are starting to look a little bit with disfavor on what we're calling serial plaintiffs and tester plaintiffs, and they're holding them to a much stricter standard, requiring that they plead their claims with more specificity, that they need to show proof of a more concrete injury. Because the problem is that a lot of these cases are often filed by the same handful of law firms on behalf of the same plaintiffs, whether individually or on behalf of the class. And when we talk about a tester plaintiff, that's referring to plaintiffs who basically their job is just to go to websites, and they're scoping out websites looking for ADA violations. That way the law firm can bring a lawsuit. And in the meantime, they never really had any intention of using that company's product or services. And these laws were, and these cases were really intended for people who were really harmed and weren't able to enjoy, have the same equal enjoyment with the use of a website as someone who was not disabled. They went to make a purchase and they couldn't do it. Not just, hey, I went to your website and you're in violation. Okay, well, where's your harm? So, that's the good news. But, needless to say, these cases are still on the rise, and it's something to, really take heed of. So the big question is, who's at risk for getting sued? Well, virtually any business with a web presence may be at risk. And it doesn't matter whether you're a Fortune 500 company or a sole proprietor. And the number of employees you have is irrelevant. So that said, there are certain industries that are getting hit the hardest. As you'll see from the slide, retail and e-commerce, not surprisingly, is the front runner by a very far lead. And the reason for that is, the reality is they're an easy target. They're more commonly accessed, by the masses, in contrast, for example, to perhaps, a local dental practice. And also their sites tend to be much more complex with more frequent updates. Jeff, did you want to kick in on some of this?
Yeah, no, it's just, certainly, right, like you said, e-commerce is certainly right up there. One of the things that I'm seeing on my side is also B2B in the world of transactional, non-transactional is on the rise as well. So it's not necessarily that if you're just an e-com shop, selling, sort of consumer goods, it's also pervasive out there, and it's growing on its interest legally through these complaints.
Yeah, absolutely. Good points. And I apologize if you're hearing background noise, but my office fire alarm just went off. Let's hope I don't get evacuated. My apologies. You can't make it up. Next slide, please. So as you'll see from the slide, the states of New York, California, and Florida receive the most case filings. And the reason for this is that they, first of all, tend to be plaintiff-friendly states. Most of the cases in Florida are filed in federal court. However, in New York and California, we're seeing suits that are filed both in federal and state court. And that's because both of those states have state laws that are similar to the federal ADA, which are often bootstrapped into the federal claims. And unlike the ADA, they allow for statutory damages, which we'll discuss in a little bit. Next slide, please.
Yeah, so we're going to launch into our second poll, which is our knowledge check real quick. So if you would launch that, this one asks if your business receives an ADA website compliance claim from a plaintiff, what do you think is the best first step to take? So A says, contact an attorney with ADA compliance experience. B is make an immediate change to your website to address the cited violations. C, wait to see if other claims are filed before taking actions, or D, both A and B. So if you would see what your response is to this question, please cast your vote if you would, and then we're gonna come up with a quick response. So let's keep moving and let's see what the responses dictate. Ah, very good, very good. Therese, what do you think?
Oh, I'm very happy with that answer, Jeff. I couldn't ask for anything better. Although I will say that, most definitely, you should contact your attorney who has some experience in this area as your first step. But I will tell you that, 9 times out of 10, the first thing we're advising is, the first thing you're going to have to do is remediate at minimum the specific allegations that are in the complaint just to get the ball rolling.
Hence the 33%. Great. So if we close the poll and move on to the next slide.
Okay, so, let's talk a little bit about the complaints themselves. Most of the claims that I've seen filed, most of the claims that are out there are typically filed by plaintiffs who are visually impaired, who use assistive technology like a screen reader to surf a website. And if the website is not ADA compliant, those screen readers are pretty useless. However, that being the case, there are also cases that have been filed with plaintiffs who have auditory disabilities. So, for example, if your website has videos with sound, but they're not closed captioned, that could cause a violation. We also see claims where the user is unable to complete a simple task. For example, it could be, checking out their cart, or perhaps, even just signing up for your newsletter or more information, and other similar type WCAG violations that Jeff will get into at a little bit later date. Sometimes, accessibility widgets are used by websites, and those are actually listed as a barrier, and we'll get into that a little bit later in the presentation as well, and lack of a published accessibility statement. So, the interesting thing about the ADA is that, as prevalent as these cases are, there are only 2 types of relief, and that is injunctive relief, which mandates that you have to make your site ADA compliant, and attorney's fees. Attorney's fees are awarded to the prevailing party. And this is one of the reasons why, there's such a surge in these lawsuits, because while the disabled plaintiffs are gaining access to websites, which of course is an important factor, the attorneys are hitting a huge payday on the plaintiff side because, actually what some people have deemed to be legal extortion, because they're profiting whether a case settles or whether it litigates. So ultimately, they're the winners in the long run. But that having been said, a lot of cases that are brought under sometimes bootstrap in, as I mentioned earlier, state law, because the state laws do provide for statutory damages. So in New York and California, for example, you've got the California UNRRA Act, which provides for a minimum of $4,000 in statutory damages per incident of discrimination. So just think about that, and plus attorney's fees. If you're an e-commerce site and you've got, pages and pages and pages of products for sale, and you're not web compliant, and each and every one of those is deemed to be a violation, you could see how quickly these damages could add up under the state laws. Now, in New York, we've both got the New York City as well as the New York State human rights law. They're not quite as bad as California. Their damages are up to $500 per violation. But at the end of the day, the crux of why these litigations have become so prolific really is the award of attorney's fees to the prevailing party. So let's go to the next slide. So God forbid, but hey, it happens. You've gotten a complaint or you've gotten a demand letter. What do you do? Aside from first call your attorney. Basically, you have 2 options. You can either litigate it or you're going to settle it. And that's usually pretty much it. If you're going to litigate it, the 2 options are filing an answer with affirmative defenses, or making a motion to dismiss. And how do you decide, what are you going to do? Well, you work with your attorney, and the best way of assessing a plan of attack is, first and foremost, confirm that the allegations are accurate. When they conduct these audits of websites, the site coding is usually analyzed by firms with a free web crawler program, and they're not always accurate. Also another thing you need to do is check to see other allegations with specificity. One of the common practices that I see in these complaints is that they're simply copy paste jobs. I laugh sometimes when I get these complaints in, because the only thing that's changed, particularly when it's from the same law firm, is the only thing different is the name of the parties, and sometimes not even the name of the plaintiff, is the name of the defendant and the web address and the amounts being sought. It's just crazy. So
Crazy.
that's something else very important to check. And then, of course, what jurisdiction are you getting sued in? Because as I mentioned earlier, that's going to be important because it's going to vary in terms of what the state of the law is. You know, is just a website sufficient? Do you need a nexus to a physical location? Do you have a physical location? You know, then you also need to assess, do you have any potential defenses? You know, and what are the cost and time factors that are going to be involved with respect to both litigating, settlement, and then remediation of the site? Because whether you settle or whether you litigate, if your site's not compliant, you're going to have to remediate. So that has to always be factored in from a time and cost perspective. So, you know, in terms of your potential defenses, you know, some of the things to take into consideration is that, you know, is there an argument that the website is not a place of public accommodation? Now, likely a loser at this point, but then again, you've got to check what jurisdiction you're in. If you're in New York, California, Florida, where most of the cases are filed, we know that that's going to be a loser. If the violations have been caused by the reason of third-party plugins, for example, that you don't control, well, compliance under the law can't be unreasonably burdensome, so you may have that as a potential hook for a defense. What about if the plaintiff has not shown a concrete injury? What if it looks like they're just one of these tester plaintiffs? Well, you may be able to argue that the plaintiff has a lack of standing to bring the claim. You know, similarly, if there's a lack of specificity in the allegations, perhaps you can make a motion to dismiss on those grounds. That one usually doesn't work because but it is something to consider, but it does risk the possibility that the court will simply come down with an order that enables the plaintiff an opportunity to file an amended complaint. But all things to take into consideration. You know, and of course, your best defense is your site remediated already? I have seen that happen. You know, or is your remediation underway? How far underway is it? Because all of that is going to play in whether you want to fight or do you want to settle. But, you know, one thing to keep in mind that unless you have a really, really good defense, litigation is going to very quickly run up costs and legal fees. And you've got to keep in mind and take into consideration that the prevailing party is going to be entitled to their fees. So, you know, that there's always that danger, particularly since a lot of the judges do tend to be very plaintiff friendly, even though we are starting to see a trend in the other direction where judges are getting, as I mentioned earlier, a little fed up and tired of some of these serial plaintiffs. And one thing I didn't mention, when you talk about serial plaintiffs, you frequently see mentioned in some of the court decisions, as well as, you know, articles on this topic, that it's not uncommon for the same plaintiff and law firm to file 50 complaints in the same day. So, you know, kind of loses a little bit of credibility that, yeah, did that same plaintiff really go to each and every one of these 50 independent sites, ranging anywhere from retail to dental to doctor to travel to hospitality, et cetera, et cetera, et cetera. And they were planning to use all of these businesses, goods and services. So, you know, we'll see where that turns, but, you know, certainly judges are becoming a little bit more conscious of that issue. One other thing to take into consideration when deciding whether or not to litigate is the fact that some jurisdictions require mandatory mediation. So you may be better off settling sooner rather than later before a court forces you to, and you've already, you know, underwent, you know, the cost and expense of litigating a bit. And also, if you're in federal court, it tends to move on a very fast track. They have early on mandatory disclosures. There's an initial case management conference, case management orders that give you a very fast track on scope and timing on discovery. So again, things really to take into consideration. And then, of course, last and not least, but most important, you've got to assess the current status of your site's compliance. You know, are you 100% not in compliant? Were you on track to be compliant, et cetera, et cetera? And that's something that would require an audit of your website that Jeff will be discussing in more detail shortly. Next slide, please.
Yeah, so I'm going to jump in here real quick, right? So as part of the legal process, and Teresa sort of hedged on it a little bit here. What are the things that you need to do, and who are the people that are involved? So, as part of that remediation understanding and some of the aspects that are coming in through the complaint, those are your priorities, right? You have to hit those as fast as possible. You have to put together a team, as you can see from the graphic to the right, that consists of pretty much everybody, right? Because in the world of web, you have a bunch of different people. You have content people, you have web designers, you have web developers, people working with code. Yeah, you have the attorney. That's as part of the complaint. And you're really all focused on that claim. So as Teresa said, you really want to get to that remediation. You want to delineate all those specific pieces that are within that complaint, which can be fairly difficult. I have to tell you, some of the stuff is pretty easy. Some of the stuff is pretty difficult. And then as you're doing that, you want to do the accessibility web audit. Same thing that Teresa said. And we'll get a little bit more about what that looks like and some of the options available there. Right. But you really have to build that team or have that team ready, and everybody's got to be on the same, field and collaborating so that that can be remediated in pretty swift order. And then again, like, Teresa and I are definitely going to go back on a lot of things that we're going to agree on here. And that's the accessibility statement that should be posted most likely in your footer, where it's a global link where you can get to it from all different pages. All right, next slide, please.
All righty, thank you, Jeff. So to wrap up the legal side of this, as a practical matter, most of these cases do settle, which of course the plaintiffs, attorney firms are counting on, because the reality is that most people don't have the stomach, the time, or the budget to get engaged in a protracted and expensive litigation. But that having been said, well, settlement sometimes leaves a bad taste in people's mouths, particularly because, too often I hear, but I didn't even know I needed to do this. I didn't do anything wrong. It wasn't intentional. Unfortunately, ignorance of the law is no defense. And there are benefits to settlement. First and foremost, two of the things that are most important in my view, putting aside, the cost savings, is the fact that you have better control over your remediation process and the timing of that process. The last thing you want is a court dictating what you have to do to become compliant and in what time frame you need to do it, and whether or not they're going to be looking over your shoulder for X period of time or at different intervals to monitor your compliance, and have the right to, monitor you for the next year going forward. These are all things that, if you're negotiating a settlement, that you can deal with within your own parameters. And likewise, one of the other things that are very important in my view is that it could be helpful in future actions and negotiations. And why do I say this? Because one, I hate to say it, but the likelihood of getting a second suit is probably higher than not. We hope not, but hopefully, you'll bring your side up to speed and it won't be an issue. But particularly if you're a big company, a big name, and you're a deep pocket, the reality is that you're a target. I've had clients, one client in particular comes to mind, who was banging their head because their site was 95% completed in remediation, and they got hit with 2 lawsuits in 1 month, and had just gotten another lawsuit the month before. It was just insane. It was just like boom, boom, boom. So it does happen. With respect to how does it help with respect to future actions and negotiations, once you've got your settlement, you've got a plan in place. And remember, under the ADA, the only 2 remedies are the attorney's fees and injunctive relief providing for remediation. So if you've already got a remediation plan in place, that issue now became moot. So, one of the things that, I'll talk about in a few moments, is how to handle that in terms of confidentiality, et cetera. So some of the things you should consider, though, in whether or not you're going to settle is, and what type of terms you want in your settlement is, how much time is it going to take you to remediate? What's the current state of your site? How much effort is going to be needed? And how much is it going to cost you? What's the current state of your site? You know, how important is confidentiality to you? Obviously, if you litigate and there's a court order against you, that's a public record. Now, if you do settle in the midst of a litigation, you know, those settlements are confidential, but still everything else that was out there in discovery or motion practice, that's part of the record, and that is open to the public. You'll also need to take into consideration the importance of perhaps a lower settlement payment as opposed to a longer remediation period. So for example, if for whatever reason you need a year to remediate, but the plaintiff only wants to agree to 3 months, you may have to fork over a little extra money to get that extra time, you know, or if you don't care about the remediation process because you're 95% there already, then, you know, then you don't care maybe about the 3 months and, you know, you can negotiate a lower settlement payment. And also you've got to take into consideration, what's your plan for going forward? You know, how are you going to monitor your compliance and keep it compliant so that you minimize the risk of having another lawsuit? Next slide, please. So just real quick to wrap this up, you know, when you do negotiate a settlement, what are the common terms? And I'm just going to hit on what I consider the top 4 most important from my perspective and what I tend to focus on when I'm negotiating on behalf of a client. You know, the 2 terms that are always going to be there is a payment of some sort. And those dollars generally will take into consideration from the plaintiff side some type of damage, whether, you know, it was under a state law claim or federal, you know, just the reality of negotiation, and some element of attorney's fees. Usually it's not broken out unless they ask you to pay, you know, with 2 separate checks, but that is usually what plays into the ultimate number. Of course, remediation of your site is going to be a huge component and what the plan is for doing that remediation. We like to make sure that there's clear provision in there that you're not responsible for third-party content if there is a future violation. And then just real quick, confidentiality. You know, it's very important to have a confidentiality provision, but I like to have it with a carve out. And what I want to always do is have that carve out that you can use that settlement agreement in the event of a future litigation, but with the proviso that the payment information and the party information will be redacted so that any of that confidential information isn't there. But what you can use is a remediation plan, because that's going to be your sword now in a future litigation to show, hey, that issue's moot. I already have a plan in place, and now we're going to incorporate it in any settlement that I have with you. And by the way, since I have a plan in place, that's going to affect the dollars. So now maybe instead of, you know, paying $10,000, $20,000, $30,000 to settle, maybe you could get away with, you know, a much lower nuisance value settlement. And with that, I'll turn it over to you.
Awesome. So I think we're going to launch our last poll question right now. If you would, yeah, great. So let's test our knowledge here. So what do you think is the most important option to achieving ADA compliance, website compliance? A, designing and remediating your website based on top claim reasons or issues for ADA non-compliance. B, designing and remediating your website with WCAG 2.0, 2.1, and 2.2 guidelines, remediating your website based on a recent claim, and not sure which one is best to take. So if you would just cast your vote real quick, we'll get the responses. One of the things that we're going to be doing as a sort of a change in the program is now we're going to sort of take it from a little bit more of a proactive approach. So let's you know, see what the results are, and then I'm going to have a bunch of different slides that have practical understanding as to what it is. So resounding, design and remediate your website to the guidelines. And thank you very much, everyone. Well done. So if you didn't know, that's exactly what we're going to be talking about now. So we get out the poll and hit us with the next slide. That would be great. Okay. So let's start with the positives, right? What are the things? So this is a whole different way of thinking, right? So this is the digital pathway to compliance, right? This is more of a proactive understanding, and something that what Teresa's leaving us with is like, you know, what is your plan type of deal. So I'm going to leave this up so you guys can take a read on it. I'm going to cover it in broad strokes, but I want you to hear what the opposite side has to say. What are some of the negatives that come as a result, right? So as we know, legal risk, right? So there's lawsuits, penalties, regulatory fines. You heard some of the iterations of different examples and amounts that came from what Teresa just presented. You know, financial impact, right? Cost of litigation, remediation costs, potential loss of business for sure. And then it just sort of escalates a little bit here to reputation damage, public perception, brand loyalty, when you get into things like e-commerce and some of these other transactional, non-transactional websites, exclusion of potential customers, right? So you're basically reducing your market reach, right? And then negative user experience is part of that. We'll talk about SEO in a second. And then there's operational stuff, right? Where you can increase your customer support understanding. So anything that's like, help me convert this on a web platform so I can order this, or, what is this information that goes back to some type of customer service organization within your company, and that sort of escalates as that inaccessibility of your website takes hold, and that it directly affects employee productivity. So now you're shifting your business to a more of a cost-based model rather than a budgeted understanding. And so those are the sort of the negatives, right? And it's just like real high view type of understanding. So the benefits, obviously, you're going to be going into your website, you're going to be doing remediation of those particular areas, and you're going to enhance your SEO understandings, right? So we'll get into some of the use case understandings in just a bit. I'll give you three slides on the sort of the top areas of those claim, so that you can take a very visual understanding about what the differences are. But there, like, I think, Teresa, I remember there were about 15 top, sort of claim areas as far as I sort of enumerate them, sort of on the technology side. I don't know if there's, something else that you guys go by, but, those are the things that I sort of see as like, a little bit of like everything that's pervasive in these claims. Okay, cool. And then, of course, one of the things that you're going to do is Google's now looking at this, right, from an accessibility understanding. So web rankings, right, to increase your or boost your search rankings, and then have that visibility from a brand understanding is that you recognize ADA accessibility, and you're working towards compliance through statements. All right, next slide, please. Okay, great. So let's break this down a little bit, right? So we talked about the web content accessibility guidelines, right? So content, right? So what is that? What does that include, right? So we're going to go through the four principles pretty quickly. I'll give you a little bit more about that, and then some of the elements of this content, right? Something you should know about, right? So on perceivable, you can read through some of the bullet points, but what's behind, right, are text alternatives for non-text content, right? So you have to give some labeling to it so everybody hears about or understands about alt text and some of those elements. Captions for multimedia go under perceivable, right? So that you have to look at like things like multimedia video and so forth, so that you have some understanding of what they refer to as time-based media, right? Video and so forth. Content adaptability, so resizing tags, responsive design, being adjustable and be presented in different ways, so that people with these different types of engagements through their disability can have that understanding, and just distinguishable content, right? We'll talk a little bit more about what these look like, but on color contrast or contrast ratio and so forth, text visibility and so and all, right? Again, these are going to be examples you'll be seeing in just a second. So moving down to operable, right? So this is a big area, right? So keyboard accessibility, right, of content. And that is, what are all the functions available from the keyboard? So just subtract your mouse, turn your mouse off, unplug it from your computer. Now navigate your website. Okay, that's what you're looking at. Okay, sufficient time for users, right, to read and use the content, right? Sometimes there's timed elements, right? So I think there's some legal case out there. I'm not quite sure, Teresa, if you heard, but I'm hearing some peerings through, especially on the ticket area, where there's these countdown clocks of getting that information out. Now, I don't know if that's going through or not because it's part of a checkout process, but it is sort of like a little thing where if you have a timed element on your website, you have to give enough information during that timed element in order to make that accessible, to make that decision. Okay. That includes all the different elements of things that could go wrong during that conversion point or that checkout scenario. Okay. Next part about operable is no content that causes seizures, right? So you can't design ways that things are like flashing or has that type of element to it, so that it would cause that unfortunate disability. And then navigating content, right? So be very clean with your understandings of navigation, right? What's expected? What are the headings? What are the labels? Be very purposeful, okay? So understandable, right, is readable text, right? Make sure it's just makes sense, okay? Very simply, predictable web page is very close to operable, but it's understandable, so that I understand the navigation, understanding how your website's laid out, so forth, site maps and so forth should be available for that as well. Input is assistance, right? So what happens if I run into an error on the website, right? Like I'm filling out a form. How am I going to give that navigation, that clear instruction as to what next steps you need to take, and how is that connected with things like your keyboard? And then robust has two options. It has compatibility with current and future user tools, or I think it's called user agents, right? So user agents is sort of like the technical words, right? Around things like browsers and browser extensions, Chrome extensions, media players, readers, and other applications that render content. Okay. So I wanted to give you all that as context, because that sort of underlies all these elements within the web content accessibility guidelines. So what else is content, right? So what else is content? People think content is words, images, and everything that we see on screen, right? But it's a lot of it has to do with what's behind the scenes, right? So we look at all things like alt text and so forth that relate to SEO and some of the labeling that happens. But there's a lot of code and markup language that's attributed to this engagement, and having like a clear defined structure behind that and all the elements within, and understanding, to the point that Therese made on your third party, what are those elements and how do they interact? Those are things that you should take into account. Okay, next slide, please. Okay. Right. So what we got here is who's involved, right? Why are we doing this? What's the intent of this? And a lot of it, as we've just heard through Therese, and a lot of the claims and the legal process of which you've come to understand through news and some of the press releases or whatever that are coming out, is on a user side, on a plaintiff side, right? But why these are, I think, originally put together also is to really inform, train, and have as a set almost standard to give development firms like myself, like an agency or a content strategist or site designers and so forth, this sort of pathway to say, hey, listen, this is the guideline. You should know about all these different guidelines that are in this, and you should be able to adapt what you're doing, not only for a development understanding, but also what you currently have online. So all of these people, I think I mentioned this before when we were talking about remediation on a claim, same thing goes here, right? So get that plan, like Therese said, right? One of the other things that's also part about it of this is all the different technology that's out there on the tool side, right? So not only on those that are readers and audit pieces and so forth, but what are the tools that are helping move in that direction? So all those different elements in this sort of like web dev community are enacted. And I think the latest part of this is looking at mobile accessibility, and that just came out, I think it was October 2023 of 2.2, which I'll talk about in just a sec, where that user engagement really is something that is escalating. Okay, so let's keep going. I've got a few, next slide, please. I've got a few examples here that we run down real quick, okay? And this is a visual example of some of the top plaintiff claims, right? So I just want to really quickly, I don't want to sort of belabor the moment, but I want to give you some of the unique aspects of this besides the ones that are just visible and easily understood. So alt text, right, is the sort of the descriptive content that you put as an image or video or something like that. There's something called alternative content. And that goes within the web development tools of your website, right? So often it's the case what we've seen, through SEO searches and so forth, where you bring up an image and it says image123.jpg, right? So it doesn't tell anything about what the actual image is, but to the right of that is red car front view, okay, which is very descriptive, right? And also take a look at the syntax where they use the underscore in order to connect that information. Okay. Another big area, just to drop down very quick, are online forms and their inaccessibility. So besides the labeling that you see right there, some of the things that we see and come across, especially on the sort of the tech side of this, are a number of things, right? One, you have to take a look, and something I'm going to be showing you in just a moment is, what is the contrast ratio between the foreground and the background? We'll talk about that. A big no-no in this world is the text that goes inside of each one of the fields, or something called placeholder. That placeholder content messes up the readers, right? There's like a voice change or something like that goes on, it gets garbled or something, and then the person doesn't understand what you're doing. And it also usually is at a contrast ratio, which is very low. So the white background or a very light gray, usually, to like just a couple of steps, darker gray or something like that. That, again, complete no-no. And so the more descriptive you are in the world of forms, and forms is actually a huge area that has a lot of technology issues with it as well. But the last bullet point here under forms also is incredibly important, is like, what is that user guidance, right? Once you're doing something and you make a mistake, right? Usually you get something that's in red that pops up and you're like, oh, okay. And then with a mouse, you could just like click into it, that type of stuff. Just imagine you're just using a keyboard, right? What's that navigation understanding? And is the instructions clear enough that I know which field you're talking about? So just imagine going to a form and you get most of the form wrong, right? Now you have like 4 different things on the form that they have to figure out. They all have the same label, right? What do you do, right? Okay. So you understand perspective, right? So next slide, please. Okay, so big one, right? Mouse only navigation lacks keyboard navigation. It's one of my all-time faves in the world of ADA compliance, because like I just was alluding to, right? What does that look like, right? And there's a big world out there. One of the things to keep in mind also, besides the actual just navigation with your keyboard, is as you're going through it, and we'll see it just as an example, I think, in one last slide here relative to forms, is what is the visible selection of that element? Is it visible? Does it make a difference? Can I see it visibly? What type of explanation is there, right? And then what's the navigation understanding of that page? So there's a lot of different types of linking that can happen on a page that streamlines things. So just imagine if you're on a page, right? No mouse, and then you have to go down to the end of the page, right? And then so you're tabbing all the way down to the end of the page, you're going through all the menus and all that stuff, going through all the content, and then you make a mistake, right? And then you have to go back. Well, if you go back, does that take you all the way to the top and you have to tab all the way down, that type of thing? So there's, again, this goes back to sort of the design considerations, the development understandings, what type of links that you could put with on the page that make this more accessible, simply more easier to work with. Right. And then the last piece is the what they refer to as color contrast, or what I refer to in this particular case is contrast ratio. And I know that this slide, it seems a little bit small to you, but what we're trying to do here is give you on the left side something that's a very low contrast ratio, which is very two different grays that are very similar, from a hex code understanding, A6s versus B4s. And you get to see that 1.32 to 1 is very narrow, right? You really can't differentiate that. And then on the other side, which is, that basically black and white, right? Zeros versus Fs, you got 21 to 1. Now, the ratio, from what I understand, is 4.5 to 1, which is a very understandable, and it gives a really good design aspect to it and so forth, so that you can have that sort of pass fail understanding. There's a number of different aspects that you have to test in that particular way that relate to various browsers and how that gets interpreted, and then all those different types of tools of which that can give you sort of this pass fail understanding throughout. Okay, last slide in the series, I think, one more, sorry, I'm behind on my side, is this understanding of, what part of the color loan to give information, right? So colorblind people, just imagine you're going on to a form, you're tabbing through things, you're colorblind, you don't see the difference, right? And so what type of cues can you give so that that type of screen reader can then pull out? But guess what? Screen readers don't read color, okay? Oh, so what else can I do? What are my options, right? So that's one element. The other thing, just to skip ahead in the interest of time, we're really coming down to it very quickly, is captions for video, right? So video is pervasive, right? And it's really going gangbusters out there. So the world of YouTube, you can just click on closed captions. One of the best examples of closed captions for accessibility, believe it or not, is The Lion King. So if you're watching The Lion King, you turn off the audio, you get to read actually all the music cues and everything like that. All right, next slide, please. So there's a lot to this slide. So what I'm trying to do here is just give you some understanding. So in the interest of time, I'm just going to paraphrase what I originally intended to present. But there's different classifications, right? And the whole idea about proactive or reactive, right? So what often is faced with people is like the words of 100%, the words of ensure or guaranteed. Those are very difficult to approach, and those questions should not be asked. The question, and the one that we related to in the poll, is how close I am to compliance, right? And we talked about those modalities, right? We talked about how ADA is enforced by the Department of Justice, so you know exactly what those guidelines are. And those guidelines are faced in various understandings of conformance, right? So real quickly, what we like to do as a baseline is conformance of 2.1 AA. Okay, that's where we start, right? We say that's our baseline. 2.0 is something that was done back, I think it was 2008, if I'm not mistaken. 2.1 is 2020, and 2.2 just came out, I think, 23. And they all have different classifications, but they all build on one of the other. There's no like sort of backwards type of things on correction. It's just it builds on successively, right? And each have criteria. So right now we're up to 87, I think it is, a success criteria, where it used to be like 60 or something. And so that's something to really understand. And there's quite a bit to it. Each one of the success criteria is quite involved. So I want to get to the last piece here on automated scans, right? There are some elements here on formatting and color contrast and stuff like that, and prioritizing common claims and all that. But I wanted to approach that. So if we would go to the last slide, please. And we're talking to this real quick, right? We got a couple of minutes, I think. So in automated versus manual, right? So automated is like a first step, right? You really want to just get in and understand that here are some of the key areas of which I have in order to address. A manual scan or a manual remediation or a manual audit really is comprehensive, is very detailed, and it gives you a structure on strategies, right? It's like, okay, here's something that you really should address. Here are all those groups. Here's something that's a little bit long lead that gets you into that, and it works towards back to that level of conformance, right? So 2.1 AA is where you want to set your standard, and then you're working back towards that conformance, right? So I wanted to get that to you. And I also want to bestow to you that overlays and widgets are now officially a part of the problem, right? So Therese mentioned that real quick. It's the type of thing where you can't rely on what's going on there. Yes, it is again a sort of a first step type of approach that gives you different types of settings that you can do things on scaling and so forth. Great, but it can also be deemed as something that as an encumbrance on conformance. Okay, so these are things, and all different types of websites have them. A lot of e-com, right? But there's also things out there from an informational understanding, blogs and so forth that are on this like almost B2B and B2B understandings where people are just placing this stuff up and say, oh, we're conformed, right? We're in. Okay, don't take that position, please. Okay. And the last thing I'm going to leave you with, and I'm sorry we're top of the hour, is please look at this as an ongoing process and detail some of the work that you have. Take it out, do it in a phased approach. Get with the pros because they know it well, and or if you have people on the inside, get your team together and set a plan. That'd be great. All right. So I don't think we have any time for Q&As, but Teresa, is there anything that you would like to say before we leave?
No, I think this is great and very helpful, Jeff, laying out particularly how to remediate the site and the work that goes on behind the scenes and why it's so important. Sorry we don't have time for questions, but certainly Jeff will put up our contact information and feel free to reach out to either of us directly with any questions. We'd be happy to assist.
Absolutely. Thank you very much, Therese. It's been wonderful, wonderful. This is an amazing experience because you've got, the legal side and also the development side on the same platform, talking about the same things, that type of stuff in lockstep. So please reach out to us and whatever type of, questions you have. Welcome to field them. Thank you again, everybody, for joining. We did fill out an hour. We didn't think we were going to do it, but thank you for hanging on. I wish you the best and have a great day. Thank you.
Thank you, everyone. Take care.